Welcome to the Society of Construction Law Australia's podcast, the podcast where we look at legal and technical issues facing the Australian construction industry. My name's Melissa Yeo, and I'm chair of the Society's Communications Subcommittee. In this episode, we bring you part 2 of my discussion with Matthew Hickey of Level 27 Chambers in Brisbane and Petrina Macpherson of Minter Ellison on the brave new world of online hearings. This episode kicks off with their top tips for ensuring your foray into online hearings goes smoothly, and includes a fascinating discussion about lighting, green screens, and how online hearings afford an opportunity to advocate in ways you never considered before. I'd like to know more about cross-examining through an internet connection. I'm very, very curious as to if it was what you expected it to be.
The thing for me is there are advantages and disadvantages. The advantages are if your opponent hasn't thought carefully about how their witness is going to be framed up, then you have an extreme close-up of a person that typically if you were cross-examining in a room you wouldn't have. So, for instance, typically in most court or arbitral contexts, you would be in a room and they would be a number of metres away from you, and you would have a general sense of when you're cross-examining where the pressure points are and how they're responding physically and where they're irritated by things or where they feel stressed by particular lines of inquiry. But you don't see the whites of their eyes, if you know what I mean. Whereas in video, you see it. Everything is given away, everything. Unless your opponent has done what you should do, which is to give real thought to how you can most effectively frame up your witness so that they can be seen, but not so much that they give everything away.
So would you sit them further back?
I think there's real strategy in this. I when we were conferring with our witnesses, I actually gave real thought to who do I want where. And in fact, part of the process of conferring with them was to say, listen, is this, because most of them were at home, is this where you're going to be to give evidence? Can you shut that window behind you and pull the blind because there's all of this glare? Can you ensure that you're this far away from the camera, not as close as you are now? You know, again, it's that Cecil B. DeMille kind of stuff. There is advocacy in how you stage witnesses, and I don't think any of that's improper. I think it's actually part of the advocate's job to think about, I'm leading the evidence from this person. How do I present them to the people who are going to hear from them? So that's the advantage in a way. You can stage manage how your witness will present on screen. But there's this really interesting thing with video, which is, you know, when we sit here in person and talk to each other, it's immediate. You know, I say something, you immediately respond, and we can feel this kind of visceral human interaction.
It flows a lot easier than it does on a conference call or a webinar.
Whereas on a webinar, even with the fastest internet connection, there's this barely perceptible, and frankly, I think for the most part, it's imperceptible lag. There's a delay such that your brain recognises it at a subconscious level. It's not immediate in the way it would be if we were here together. And that's both confusing at a subconscious level, but also tiring. And so when you're cross-examining a person, you expect particular kinds of responses, I suppose, and then you begin to second-guess their responses. So you begin to sort of perceive, okay, well, they've responded in this kind of way, but it's not. Is it because of the delay? You know, there's this kind of mind chatter that goes on, I think, in that process, which is really quite interesting. And the other thing, of course, is that you don't have the immediate physicality of cross-examination. Now, I'm not a sort of table thumper and a shouter. I think most sort of sophisticated counsel these days tend not to be, but there is still a degree of physicality in the approach of cross-examining. You know, you have in your mind an idea of, well, when I get to this point, I'm going to craft the cross-examination so that I am exerting pressure on this person. And there is a physicality to that, which you can't do on screen. And one reason often is, depending on how you've set it up, you might well be presenting sitting down. And advocates in this jurisdiction often talk about how weird it feels to go to QCAT, for instance, the Civil and Administrative Tribunal here in Queensland, because you make submissions sitting down rather than standing up. There's this kind of muscle memory in that. So for me, that is probably one of the downsides of hearing in video, is that you don't have that immediacy. And the other thing, of course, is, again, in a room like this, you have control over the volume of your voice. How you hear me is something over which I have control. I can speak louder in this room altogether, and you hear that because I control it. Whereas over a microphone, how I sound to you depends very much on what kind of speakers you have at your end, how loud or soft you have me turned up.
What the guy from Epic is doing.
All of that, right? And so, you lose elements of control that I think you take for granted as an advocate in person. Yeah, it's interesting.
Another tip, big tip, if you're using a laptop, don't rest it on the desk. Bring it up to eye level. There was one particular witness who had a laptop and it was lower and, you could see up his nose and it just looked wrong.
It's never a good look
never
for most
a good
people.
Look.
Yeah.
So, yeah.
Can you tell me a few other things that we really need to bear in mind before we embark upon our first online hearing?
Well, trials are... they're called trials for a reason. As an old barrister once said to me, they're not called easies. And I remember at the time cringing, but I have found myself repeating that to junior solicitors, much to my own embarrassment a few times.
It's amazing what sticks with you from your formative years.
I know. So trials are inherently difficult. Doing it as a virtual hearing adds an extra layer of stress, and it is a mentally taxing and exhausting way to conduct a hearing. I found myself shattered at the end of every day. You have to listen more closely. We found what worked best for us was we literally had to have almost a team of listeners.
Yeah.
So I was the main instructing solicitor, and then I had a junior whose job was to write down questions. So questions asked by the other side or by our counsel, and then one dedicated to writing down document numbers. So what document was that? We just had it there because it was impossible for one person just to catch everything. And we didn't have a real-time transcript, so we only got the transcript at the end of each day. So we had to take good notes as we went through. So it required a bit of team effort to make sure we captured everything. Make sure, whatever you do, make sure you test the technology before your first day of hearing.
You would think that would be obvious in how it would.
No, have a session with the arbitrator, with the other side, and test everything.
Yep.
And we did that, and our test, thank God we did it, because everything that could go wrong did go wrong. And I remember walking out of the room going, oh my God, this is going to be a disaster. This is never going to work. And sure enough, everything got sorted. And by the Monday when we started, it was fine. So have a test rehearsal. Think about the formality. Maybe because I'm a little bit of a stickler, I insisted that everyone who came into our hearing room dressed appropriately.
Yep.
The men wore ties, we wore jackets. We treated it like a trial.
Yep.
We just had that mentality, which I think is important. You don't want to bring the relaxed attitude that has crept into some of the Zoom meetings that we've seen. And
that's quite an important point.
Keep your pants on.
Please. Especially if you're going to stand up. Yeah. But the formality thing is a really important one because it is, I think, because we have all been Zooming and what have you, and frequently from our homes, we've been forgiving of each other in ways that I think are really great for the legal profession. There's a diminution of formality in places where we're all the better for it. But anecdotally, it's really interesting. I've spoken to judges here in Queensland who have said they've noticed, or at least they did during the period where we were regularly conducting hearings electronically, a decline in formality, not so much in the way they were addressed or the way people were dressed, but things like reading your material, for instance, formally saying, I read this and that and the other thing, things which barristers or solicitors would never sort of typically do in court because it's just part of the routine of, well, I go to court and I do these things. The technology means that it's easy to slip out of the formality of the place. And so I can't impress upon people enough that having something in place that reminds you we're in a formal process here so that you don't inadvertently slip out of it.
Absolutely. And your point, Petrina, about keeping your pants on. No, but in all seriousness, the entire point I think we were discussing before we were recording, again, it cannot be forgotten that court arbitral hearings, they command a level of respect and that is conveyed through your attire, through the manner in which you present yourself.
Absolutely.
And it's something that absolutely cannot be lost. It is part of your advocacy as well before you open your mouth. And certainly I would be horrified if I knew that counsel on the other side was cross-examining from, his desk sans pants.
Yeah. With the boardies or less.
Boardies, but absolutely a tie, a jacket, what have you.
It should go without saying.
It should go without saying. You should be rocking up as if you're rocking up to court.
Absolutely.
And it is court.
Yep.
Now, eMediations. You guys done a couple of those?
Yeah, I've done a number of mediations this year, both as counsel for one of the parties and as a mediator. And I think, again, it's going to be one of those things which will stick around. Yep. I think, again, it goes without saying that it's better to do it in person. But again, all of the things we've talked about, I suppose, in terms of hearings are equally applicable to that forum. And in particular, I think consideration needs to be given to who will appear on screen, how you will present yourselves on screen, who will do the talking, where they will be positioned by reference to microphones. And it's for this reason, I suppose, we all understand that in a mediation, particularly in a plenary session, if there's a degree of animosity between the parties, there's that sort of sticky, awkward feeling around the table when nobody can look each other in the eye and, you can feel the hostility boiling from opposite sides of the table. That can be exacerbated, was my observation, when, for instance, one party is sitting in a room all together and so they appear small on screen, but another party appears with their solicitor in one screen and their party separately together. So one party assumes visually greater significance than the other party. And
through
again,
an accident of technology.
Yeah, quite. And again, it's a subconscious kind of thing, but it sets a kind of a tone where one party sort of thinks, well, that other person who's on their own on the screen seems to have an awful lot more to say. And what's been really interesting for me as a mediator is to see the way the technology has disrupted more than perhaps it usually does, the ability for people to move from their entrenched positions. It's a really interesting kind of thing. I must say I've found the technology, if used well, very good. That is to say, if you're being mediated by somebody who understands the way, take Zoom, for instance, has the ability to have breakout rooms so that you can very quickly move from one space to another and then bring everybody back together and then send them all back out into their rooms again. It's actually really quite efficient. But if you're in a mediation where people don't know how that technology works, it's so laborious and time-consuming. So I guess I would say to people, if you're a mediator, then for God's sake, get on top of the technology.
Yeah.
If you are the mediated, then insist upon people who know how the technology works. And if you're sold a pup, if the mediator says, I know how it works, and then you turn up and find they don't know how it works, then have a quiet word after the fact. Because I actually do think it behoves all of us now, until there's a vaccine, to get to use these tools. Our secondary obligation after the duty to the court is to the clients, of course. And so you don't do them any favours if you can't use these basic tools.
That's right.
So all of the things we've said about hearings apply equally, it seems to me, to mediations. You need to give thought to the technology. In the mediations I've been involved where they've been most successful, people have been willing ahead of time to agree protocols. This is the platform we'll use. These are the people who'll be there. This is who will control who comes and goes. This is the person that will send the invitation out. All of that kind of stuff needs to be thought of ahead of time. And again, document management. You need to have somebody who's controlling the documents that we're all seeing at the same time.
Yeah.
And again, if it gets to the point of trading drafts of deeds at the end of the mediation, how are we going to exchange them? Is it as simple as just emailing them to one another? Are we going to display it on the screen and talk it through? These are things which, if you give some thought to ahead of time, you're more likely to resolve successfully at mediation if you're doing it electronically.
One thing I'd like to just pick up on, you mentioned previously about sort of stage managing. And it occurs to me that, God, there could be like a niche profession or a niche role for someone who is
totally
actually a stage manager.
Yeah.
In this new world.
In America, for instance, there's a whole profession of backgrounding on juries, which is unknown to us here, of course. But I do think, and look, maybe it's because of my misspent youth in show business, but there is a degree of attention to that kind of detail which you're foolish to ignore, because we are all, even if you're a person who is as, old and crusty and an elderly aging white man who's your sort of archetypical oldie worldy judge who only reads sort of Dickens, you are still somebody who, by dint of being born in this time, perceives things in a televisual way. And you will never persuade me otherwise that there is not an opportunity for taking up your client's case in a way which is super advantageous to you and puts your opponent at a disadvantage, which you are obliged to think about.
Often my experience of court matters is sometimes the successful party is the one that looks the most confident, the most calm, and the most relaxed. And they make their case as simple as possible, and the judge or decision maker just goes, I trust those people. Yeah. And so you need to work out a way to convey that same level of, we've got this, we know what we're talking about, and do that in that televisual way.
And if that means getting a consultant in to sit down and go, you need to be here, you need to do this, wear this, do that.
If the client is so minded, and if it is a case that is worth enough, then you're going to spend a lot of money on it anyway. You may as well do it properly. Yeah.
But I think it's as simply as if you're, and I suppose I'm speaking to those who are going to be speaking to the court or tribunal, whether you're a solicitor or a barrister or whatever, I actually think you've got an obligation to inform yourself about how you look and sound on whatever medium it is you're going to be talking on. So, for instance, I'm not embarrassed to admit I spent hours before our arbitration considering how was I framed up? How did my technology work? The microphone has a gain switch, and so if I turn it this way, what does it do? If I turn it that way, what does it do? How does it affect how I sound? You can record yourself and listen to it. And it's not an act of vanity, it's an act of understanding what are the tools I have at my disposal to persuade the decider of the issues or the witnesses or my opponent about a particular kind of thing. And I think we as lawyers, particularly barristers, are reluctant to do that. It seems silly or, well, it's not substantial. I'm just about the law. Well, that's fine. But these things matter. They matter in a way that you don't understand because we've never had to do this before in this way. And I can't say it strongly enough. I think you're a fool if you don't turn your mind to these things. Or get a trusted friend, record it, let somebody else look at it and say, because we were saying before we got on record today, we all hate the way we sound when we listen to ourselves back. So get somebody who knows how you sound in person and say, listen, how does this sound? In my case, I've got my wife to listen to it. She listens to me more than anybody. Listen, how does it sound? Am I loud enough? Do I sound like I'm lecturing at you? Do I sound sort of warm and engaging, or do I sound sort of like I'm hectoring? Like how does it sound to you? Because that's important.
One of the tips I give junior lawyers when it comes to public speaking is to record yourself ahead of time and listen back to the recording. And it makes sense, I think, to do that visually as well.
Yeah.
Have someone record you. How are you going to look? What's the background look like? Do I look too dark? Can it be made lighter? Like, is the lighting too dark?
But also, do you have to do it at different times of the day? So, for instance, in my setup, so I was at home when our hearing began. I had initially tested in the morning and the light was great. By the afternoon, the sun was streaming in. And not only was it in my eyes so I couldn't see anymore, but it was sort of washed out so you couldn't actually see me on screen. So you need to kind of think about what are the times of day that I'm going to be doing this and how will it how will it change as the day progresses? The other thing is you have to confront the grim reality of your own habits. And what I mean by that is I did a webcast CPD the other day. I think I told Petrina this story where, I think, again, by dint of my sort of previous careers training, I'm probably conscious of bodily habits in a way that most normal people probably aren't. And I was horrified to discover that while I was sitting introducing this session, I was sort of doing this thing where I was kind of fidgeting with my hand, and it was so off-putting. And if I had been in a hearing and I'd sat all day long sort of fidgeting with my hand because I'd never noticed that I did it before, it would have driven somebody crazy. And so it is really quite important to scrutinise yourself really in a very exacting kind of way. And the way that, with written documents, we care very much about the font that we use and the type space and, what our corporate style guide tells us it has to look like. We care about these sorts of details, which are aesthetic details in documents. And yet we seem, my experience is people tend not to give enough thought to the presentation aspect of this, both in person, frankly, but especially on video. There's a real need to think about this stuff. And it's interesting, I think in American advocacy training, there's a lot, they're much more sophisticated about physical advocacy than I think we are in Australia. We're still in the very early stages, at least by reference to my experience of training of barristers, in thinking about these things. Yeah, something else to have to think about.
Yep.
That's it. That's the theme of this one. Something else to have to think about.
Yes, that's it. That's the takeaway.
Excellent.
Another tip I would give somebody is if you have a video, you know how in our Zoom calls there's the little video of yourself at the bottom of the screen? Get rid of that.
Yeah.
Okay.
Absolutely get rid of that because I think
you get distracted by your own face.
No, I think it is human nature that people focus on that rather than looking where they should look or rather than looking in the camera. People look, and you see it on Zoom calls all the time.
I agree with you.
It's not that we're vain, humans are vain. I just think we have a natural tendency to look at ourselves and go, oh my God, is that how I really look?
Yeah.
Does my lip curl when I say that word? Oh my God. And before you know it, that's what you're focusing on rather than what you're meant to be focusing on.
It's a distraction, isn't it? I mean, it's, when we sit and talk to one another like this, of course, from time to time you think, how am I being perceived by other people? But never because you are confronted by the grim reality of how you look. You don't really turn your mind to that.
No.
And in that way, you're absolutely right. It's almost impossible at some point not to be distracted by that. And even if it's not in a self-critical kind of way, it's to ensure, do I still look the way I would wish to look? And if you turn it off, then you can just get to what you would ordinarily do, which is to just talk to people naturally.
And then get your colleague to link you if for some reason something's gone awry with your face.
Let somebody else interrogate.
Your face is frozen or something else. Exactly.
The funny thing is, though, it kind of puts me in mind. I remember when I was a singer, my teacher used to say to me, when you go on stage, that's not the time to think about technique. Nobody pays you to watch. Nobody pays you to watch you think about your technique on stage. They pay you to be entertained. And I think it's a little bit the same kind of thing. If you are distracted by the video of yourself and being assessing it in any way, then you are distracted from the thing you are there to do, which is to advocate your client's case. By all means, have somebody else that you know well and trust scrutinise your video and say, listen, you keep pushing your glasses up your nose all the time, or you pull at your ear, or you look off camera or whatever, and listen to those people. But don't do it yourself in the moment. I think it's really, that's such a good point.
Too much to have to think about. I mean,
it's just another thing to have to think about.
It's just another thing to have to think about.
Yeah, totally.
Yep, absolutely.
Totally. That's such a good point.
That's the hashtag for this episode, by the way.
Too much to think about.
Too much to think about. Another thing to think about.
It's the title of my memoir.
In the lead up to the start of the hearing, I was amazed at how much time I devoted to this new format and having to think about things I'd never thought about before.
Yeah.
And I'm certainly not a newbie when it comes to trials and running hearings and in that instructing solicitor role.
Was it also the first time for your counsel as well? Were you sort of learning on the journey together?
It was for us and our team, it was a first for all of us. I mean, I've done electronic trials with electronic databases and video evidence, witnesses giving evidence by video link, done all of that before, but this whole new virtual hearing, it was a first for all of us. Yeah. And in fact, I'm not 100% sure, but I think I might have been the first person in the entire Brisbane office to run a full trial from start to finish in that format.
And certainly I hope that this podcast is valuable to everyone who's listening out there because, again, it's happening. Don't be afraid of it.
Yeah.
We just got to get on with it.
Yeah.
And do it as best we can. And, your first time might be shocking, but you get better.
Well, that's the thing. That's what I think the forum is very forgiving. Yeah. My experience of it has been, whether it's been court or arbitration, we all recognise this is a brave new world and we recognise that there are going to be technological glitches. So, in fact, in a way, the forum is more forgiving of you than perhaps it would be if you were doing things in the usual kind of way. Yeah. But what I think is interesting, and maybe this says something about my personality, is that it presents to a canny practitioner there's an opportunity in it. And there's a good chance your opponent is less comfortable with it than you are. Or if you can make yourself just a little bit more comfortable with it than your opponent is, there's an advantage to be had in it while the forum is forgiving.
And it shouldn't take much.
No, that's right. And it doesn't really. I mean, it's just
turning your mind to
it. That's, again, I think that's the second hashtag for the session. Right?
Yeah.
You just have to turn your mind to it.
Yeah.
Not business as usual.
Yeah.
But it can be done. And so if you just think about the other person, I mean, it sort of sounds a bit airy-fairy, but it's ultimately to your own benefit to turn your mind to these things.
Can I ask one question too? Because all three of us, we wear glasses. I am curious. You just with what you've just said there, I thought, goodness, how often is it the case that we can never see your eyes because the light is flashing into our glasses? And I, to be honest, would not have the faintest idea how you fix that.
I'm going to sound like such a nerd here, but I, in fact, had 2 sets of lights set up at home.
Okay.
One light was just so that I could see. The other light was twofold. Its purpose was twofold. One was to ensure that my eyes could be seen all the time. And the other was and hand in glove with that was to avoid the effect of the natural light moving as the day progressed.
Yeah.
Again, because I recognised 2 things. One, the light moving as the day progressed was a point of distraction for those that were watching me. But also, you're quite right. If you're wearing glasses and your eyes can't be seen, it's a subconscious impediment to people establishing rapport with you over a visual medium like that. And similarly for cross-examination, if they can't see your eyes, then that's a big problem. The other thing to think about with glasses, of course, too, is it means sometimes that reflected in your lens is whatever's on your screen.
Yes.
And so you need to turn your mind to, if I've got confidential things on my screen, for instance, messages from my instructing solicitor, and that can be seen in the reflection, then chances are your opponent can see it.
Yep.
It sounds silly, but it's
true.
stuff you actually have to think about, because if you don't, chances are your opponent is, and it's to your disadvantage.
Absolutely.
Yeah.
Hashtag one more thing to think about. Well, look, thank you very much, Matthew and Petrina, for joining me today. It's been a fantastic discussion. Really enjoyed hearing your insights into electronic trials and mediations, and I hope for our listeners out there that it has been helpful to you. Thanks very much for joining us.